Welcome everybody. I'm doing another video today. This video is going to be on debt validation. Now, the purpose of debt validation is basically if you have a collections account, no matter who is a collections from, whether it's telephone company, medical bill, whoever it's from, any collection agency, they're trying to collect a debt from you. The number one thing they have to do is validate that debt is yours. So you can Google debt validation letters and you can get them online, or you can get them from any type of credit material or something like that or that nature. I did post a version of it in somebody's post. I'm gonna try to find out who it is that I posted it to. But that same type of similar letter is basically asking the collection agency or creditor to validate that debt. So my general letter says, this is a letter in response to your claim regarding account number, whatever your account number is, which you claim that I owe you how much the amount of the debt is. And it says, be advised that the description of the procedure used to determine the accuracy and completeness of the information is hereby requested. Then it says, additionally, please provide the name, address, telephone number of each person who personally verified this alleged account so that I can inquire about how they verified it without providing any proof bearing my signature. That's the key thing right there with debt validation. They have to provide you with a contract with your signature on it. So they can't provide you with a copy of charges that they want to say that are yours that you incurred. They can't do that. Also, the letter goes on to say that as per FTC opinion letter from attorney John F. Lefevre, you should be aware that a printout of a bill or itemized documents does not constitute verification. Just like I just stated, they can't send you a copy of a bill. They can't send you a copy of charges that they want to incur on your account, on that account, saying that, okay, it's yours. Then it says, my letter goes on to state that I am again formally requesting a copy of any documents bearing my signature showing that I have a legal binding contractual obligation to pay you the alleged amount. It says, be aware that I am making a final goodwill attempt to have you clear up this matter. This item is listed incorrect and inaccurately incomplete and represents a serious error in your reporting. I am maintaining a careful record of my communications with you for the purpose of filing a complaint with the Consumer Financial Protection Bureau and the Attorney's General Office, Attorney General's Office, your local Attorney's General Office, actually. Should you continue in your non-compliance of federal laws under the Fair Debt Collection Practices Act and the Fair Credit Reporting Act, and corresponding to state local laws. I further remind you that you may be liable for your willful noncompliance. And then I list on here, failure on your behalf to provide a copy of any alleged contract or instrument bearing my signature may result in a small claims action against your company. I will be seeking a minimum of $1,000 in damages per violation. I listed defamation, negligent enablement of identity fraud, violation of the Fair Debt Collection Practices Act, including but not limited to Section 807-8. I also listed a violation of the Fair Credit Reporting Act, including but not limited to Section 623B, meaning that for creditors, they have to validate the debt as well. And basically, that's pretty much the body of the letter that I have that I send off to debt to collection agencies regarding a debt they have me in collections for, or anyone that I'm working with collections account for. And normally, by the time I get to the first or maybe the second or third letter, the account is removed. It's automatically removed off the credit report. So, I mean, if someone decides that they want to take you to court for it, it's best to show up to court and not avoid the court appointment. Because if they haven't served you any papers, or either I should say, if they haven't sent you any papers in the mail saying that they're trying to collect on that debt, they cannot collect on that debt. They cannot sue you for that debt. But you can show up to court and speak your side to the judge and state that they failed to send you documents saying that they're trying to collect on XYZ debt. So that means that they cannot go through with trying to get a judgment against you because they didn't follow the rules that they were supposed to follow. They violated a law. So by skipping to court and trying to sue you for something that they never informed you of a debt that they say you have, and they never informed you of that debt, they cannot just sue you. So, I mean, if you received the information in the mail and you just ignored it, then pretty much you did receive it, but there's no way that they can say that, okay, you received it without you being served by papers or summons or anything like that. So pretty much is if you receive the information and you knew you had the information, if you made an attempt to call them and they have you recorded, then that can be used against you as proof as well. But when they call you, you don't want to just ignore the call. You want to accept the call. And basically, when they ask you the part about your name, you can say what your name is. When they get to asking you anything as far as verifying your address and telephone number and all this and that, you don't have to comply with that. You can tell them that anything that you have to say to me, if it's regarding this account, you can have the original creditor contact me if I should owe this debt, and you can tell them to anything that they want to speak with you about over the phone, that they can just send you something in the mail and you'll respond that way. You know, you don't have to talk to them over the phone and incriminate your rights. You know, pretty much give up your rights, because if you mess around and say the wrong thing and you're being recorded, then they got you. So pretty much that's it. I mean, I've been using these debt validation letters since I began on my probably third round of disputing things off my credit report and on members of my family's credit report, and it has been working well. So I don't know what else to really say about it, except for that they have specific times that they can call you. They can call you between the hours of 8 a.m. and 9 p.m. or either 8 a.m. and 8 p.m. at night. They cannot call your job while you're at work, especially if your employer doesn't allow personal calls. They cannot call you harassing you or using profanity language or harassing any family members or speaking to anyone about your debt. They cannot do that. It's against the law for them to do that as well. It's some other things that they can't do too, but those are the ones that I can pretty much remember off the top of my head. They cannot threaten to sue you, because they cannot just do that. If they gonna do that, they can just do that, but they cannot sit there and threaten you that they're gonna garnish your wages and do all this and that, and they don't have the legal right to do that until they meet up with the judge and the judge makes that decision as far as what goes on. But you have to do your part and send them debt validation letters out, show up to court if you get summons to court, and basically cover your own butt. pretty much. Just speak up for yourself, cover your own butt. I hope this video helps somebody. It's been a long time coming since I supposed to have done this video, but my life is pretty much wrapped up in some other things right now. But that's pretty much it. So debt validation letters, what I mentioned earlier in this video, is pretty much what the letter body speaks about, and it works. So I don't know what else to really say. And that's as basic as I can get as far as what a debt validation letter is and what it's used for. I mean, you can use it for collection agencies, the original creditor. I mean, because basically, if they don't have nothing with your signature on it, they can't say it's yours. If they send you a signature that looks like it's been copied, you don't have to say that's your signature. You can say you don't recall that signing nothing that looks like that. You know, they can't prove that it's your signature. If it's not in ink, if you're not actually looking at ink on the paper, you don't even have to say that's yours. You don't have to agree to it or accept it. All right, that concludes this video. My name is Tamika Henson. Thank you.